There are several essential factors to consider in managing patient health records. They are Commonwealth and state legislation, medical board regulations, Medicare obligations, medico-legal needs, privacy and ownership issues, electronic records, new issues and risk of claims. MIP's medico-legal advisor, Dr. Rob Walters, provides some further details of these factors to minimise risk in dealing with health records.
There's a lot more to the creation, management, storage and transmission of medical records than one might think. Whilst their principal aim should be optimal patient care, the fact is that poor medical records and their misuse is often the basis of much of our medico-legal litigation. Commonwealth and state legislation enshrines 10 basic principles with regard to the issue of privacy and health information. It's worth considering the basis of each of these by way of background.
There are 10 basic principles of the Federal National Privacy Act with which compliance is necessary. These apply whether it is clinical or for research. 1. Collection. 2. Use and disclosure of information. 3. Data quality. 4. Data security. 5. Openness. 6. Access and correction. 7. Identifiers. 8. Anonymity. 9. Transborder flows. 10. Personal information.
There's a golden rule that should always be kept at the back of one's mind when making medical records. That is, would these records enable another medical professional to continue the care of this patient in a seamless fashion? Medical records must satisfy a number of criteria. Firstly, every consultation must be recorded and what occurred at that visit must be recorded and it must be recorded accurately. Any opinion given, any management undertaken, any treatment performed or any consultant opinion received or investigations undertaken must also be recorded and again must be recorded accurately within the notes. Any handwritten additions to the notes must be clear and please make it legible. Medical records are of course vital should you ever be queried by Medicare regarding a patient attendance. Your notes should reflect that the appropriate Medicare item number has indeed been charged. If you're a general practitioner, it's not a bad idea to also make a note of the length of that particular consultation. At MIPS, we know only too well how important good medical records are. It can literally be the difference between being able to defend a case successfully or not. It is a truism that if you have poor or no medical records, then you'll have a poor defence or no defence when you're in court. Now for a few do's and don'ts. Don't try to alter your medical records after the event. If you want to make additional notes, then by all means make those notes, but date them when you make the entry. Also, make sure that your diagnosis, differential diagnosis and management plan are clearly outlined. If there's an informed consent issue, make sure that it's very clearly recorded within your notes. Formalised follow-up systems are becoming a vital part of contemporary medical practice. And this has been highlighted by a couple of medico-legal judgments that have been made against doctors in recent times. There are a number of ways of setting these systems up, depending upon whether your practice is computerised or not. Find a system that reflects your practice and suits you best personally, but make sure that you have one in place. MIPS still gets a large number of queries about that age-old issue of who actually owns the notes. And can a patient actually access their notes? Well, the answer is that the doctor owns the physical records, but that the patient, through the proper processes, can access the information contained therein. There are a number of people, other than the patient, who can, in fact, with the proper authority, access those medical records. These include parents, guardians, sometimes the patient's lawyer, or a legally appointed representative or authority. The important factor, however, is that there has to be a good medical reason for accessing these records, and we have to make sure that the proper consent processes have been completed.
Privacy, ownership and release issues. Release of information without the patient's consent. You need to cooperate and release information if compelled by law. Examples include the coroner, Centrelink and the Department of Community Services. You cannot be prosecuted for releasing information in these situations. However, protect sensitive information and only release this information to other practitioners when medically necessary. Only give results to the person on whom the test was performed. Exceptions to this include children, patients with intellectual disability, or other incapacity such as unconsciousness, dementia, CVA, etc.
Many practices these days are virtually paperless, and whilst there are many advantages to the electronic health record, there are also a number of challenges. Not only is there that very basic issue of entering patient details in a new and often unfamiliar format, but there are a number of other issues that need to be considered. Firstly, protection against the loss of that data, in other words, doing a backup. Secondly, making sure that the right patient details get into the right patient file along with their investigation and any consultant's letters that may have arrived as well. Finally, there's the issue of transmission of health data and the security related to that.
Risk of claims. Unauthorised disclosure of health information can form the basis for claims of breach of confidentiality, breach of contract and invasion of privacy. Information provided to third parties increases the chances of a claim. This is an emerging risk for health professionals.
In summary then, I believe that good medical records are indeed your very best friend. Not only do they allow you to treat your patients with optimal care, but they provide you with a level of protection should your management ever be challenged. I hope you've enjoyed this module and found the issues we've raised interesting and hopefully applicable to your particular type of practice.
For medico-legal advice, call 1800 021 223